We are going live on cause number. Okay. We're going live on cause number DC 193877. National Carriers versus Dow Central Appraisal District. Council, make your appearances.
Andrew Newman and Sam Hallman on behalf of the plaintiff National Carriers.
Braden Metcalf for defendant, Dallas Central Appraisal District.
Understand we're going to be trying this on stipulated facts, but each side will have a couple minutes for opening statements if you'd like. Plaintiffs?
Yes, Your Honor. Can you, this is Andrew Newman on behalf of the plaintiff National Carrier. Can you hear me? Okay.
Yes. Yes.
Okay, I've taken the video off and I'm just going to proceed to try to avoid a lag. Your Honor, this is a case involving taxation of tangible personal property, and we are seeking a de novo review of the Appraisal Review Board order finding against our client, National Carrier. The parties have filed stipulated facts to assist the court. Would you like us to read those into the record, or would you just prefer that we have those submitted and in the record without going through it?
You can just go ahead. The court will accept this, but let's do opening statements now, and then we'll get to the evidentiary portion.
Sure. Well, we've submitted the relevant authority to the court on the Texas Property Tax Code, and this is essentially an issue of business personal property taxes, and the issue is whether or not National Carriers is subject to the taxation of personal property. In 2015, taxes were levied against National Carrier on its trucks and trailers, but it does not own the property, and the property does not have situs in Dallas County under section 2102 of the Texas Tax Code. And those are the controlling sections, and opposing counsel and I agree on that. And the issue is essentially National Carriers doesn't own the property, and the trucks and trailers that it uses and operates, they are not here in Texas. They're not based in Texas. They basically are transitory, and they're not here for more than a temporary period. So the issue is really, the taxes were levied against National Carriers incorrectly, and National Carriers paid the tax in 2015 and timely filed a protest. The trucks are owned by NCI Leasing. NCI Leasing is based in Kansas. NCI Leasing pays taxes on the trucks outside of Texas. And so what we have here is a situation where DCAD has levied tangible personal property in violation of section 2102A1 and the rest of that section. They were assessed personal property tax value notice of $9,255,550 for 2015. And they don't own the property. And so the issue is really pretty straightforward. We've stipulated to all of the facts. The property doesn't have situs here in Dallas, and it's not owned by National Carriers. And so the taxes that were paid, they were paid back in 2015. They were paid in error, and that was about $250,000. The relief that we're seeking today is in the proposed final judgment. We asked the court to find that the subject property was not owned by National Carriers Incorporated as of January 1st, 2015, and that's a stipulated fact. We asked the court to find the property did not have situs during the year 2014 or on January 1st, 2015, under Texas Property Code Section 2102. And because the property was not owned by National Carriers on January 1st, 2015, and did not have situs in Dallas County in the year 2014, we're essentially asking for the court to order the tax appraiser to revise the 2015 appraised value. The property should be, and the correct amount should be the amount of 0. And we asked the court to do this out of fairness and correctness, because it was simply an error. There's no basis for the property being taxed here in Dallas County.
So Judge Goldstein had another case in her court, I guess, that's somehow similar to this one. What
Yes.
was her case, and why is this a different case? Is it because it's a different tax year?
Yes, Your Honor, it's a different tax year. This is the 2015 tax year. And the issue before Judge Goldstein were the same parties. However, in that case, the plaintiffs were also, NCI Leasing was also named in that case. And there was a little bit more of a factual record there, but it was a 2016 tax year. So this is just a different tax year. But the same issues, same parties.
Okay.
Agree, Judge.
Response?
Yes, Your Honor. This has been a couple-year fight. We believe that the legislature intended to tax all business personal property that is used for commercial purposes in the state of Texas. The implementing legislation that Mr. Newman discussed is the correct implementing legislation. It's a 4-pronged test. They have proven through trial in Judge Goldstein's court and reaffirmed at the Court of Appeals that they do not factually meet any of the 4 prongs that we could tax them on. For example, they have trucks that are 100% of the time used for business purposes and driven in the state of Texas. So they've found the loophole in this statute. We try to get the statute corrected. We can't agree that this is a just outcome, but what we can agree to is that we've tried this exact same case in a different tax year in Judge Goldstein's court, and they prevailed. We did not. Then it was affirmed under the Court of Appeals did not give us a break on any of our arguments or let us prevail on any of our arguments. So at the trial court level, and we don't intend to appeal this any further, the appraisal district has lost this fight, although we think it's still fundamentally unfair that they can have business personal property used for commercial purposes 100% of the time in Texas and not be subject to ad valorem taxation. But that's an issue for the legislature and not for this court. And that's why we're taking the court's time today. It's a unique circumstance, but your time is needed. And we'll take the appropriate steps after this to get their refund to them as quickly as possible. And we will fight for the taxpayers and the citizens to get any property that's taxed, that we think is taxable to be taxed. And we think that's through the legislature in this case, Your Honor.
Okay, let's go ahead. And the plaintiffs, I understand, have stipulated facts they'd like to enter, as well as 2 exhibits. Is that correct?
Yes, Your Honor. We've submitted stipulated facts, and we'd like to move for entry of the stipulated facts and exhibits plaintiffs 1 and plaintiffs 2 into the record.
Any objection?
No, Your Honor.
The stipulated facts and exhibits 1 and 2 are admitted. Does defendants have any exhibits or evidence they'd like to submit?
No, Your Honor, we collaborated on the previous exhibits. So they're the plaintiff's exhibits, but we have reviewed them to make sure that everything that both sides needed were submitted in that stipulation of facts.
All right, anything additional you want to add as closing arguments?
Your Honor, thank you for your time this morning. And again, apologies for the connectivity issues. This is trial in the time of the Zoom era, so I apologize about that.
It's okay.
We would just refer the court, and we provided the court, and the reporter's been provided a copy of the appellate decision that was issued on May 5th of 2020, affirming Judge Goldstein's judgment in favor of National Carriers and NCI Leasing. That is controlling authority that opposing counsel has recognized. Essentially governs this case and helps give the court guidance on the tax issues that have been submitted in the stipulated facts.
Response?
I concur with what he said. That case is controlling, exact same facts, different tax year. there's nothing we can do to get out from underneath that. We'd ask that if the courts can find some sort of avenue for equity, we think that they should be taxed, but we realize the law doesn't say that at this point.
Yeah, I agree with DCAT on this one. I think this is for the legislature to decide. So the court will enter judgment in favor of the plaintiffs. Anything else we need to discuss today? And I'll go ahead and enter the findings of fact, conclusions of law, and the judgment as requested. So anything else we need to discuss today?
Nothing.
If they can just get me a copy of the judgment as soon as possible, we can get that refund started. Thank you, Mr.
I'll
Newman.
try to
Mr.
sign that
Tallman.
today.
Metcalf.
Okay.
All right. Thank you, Your Honor.
Thank you, guys.
Thank you, Your Honor.
So you guys are excused. We'll hopefully get that scanned in by tomorrow.
Thank you, Judge.
Thank you, Judge.
Thank you. There's still a Mr. Mum here. Mr. Mum, what are you doing here? Do you need something?